so much for joining us for our guardianship and supported decision-making meeting tonight. So let's go ahead and get started. And just a reminder for anyone who signed up late, this meeting is being recorded. And for everyone who registered, the meeting and the PowerPoints will be sent out to everyone who registered. So we will go ahead. So again, welcome everyone. Thank you very much for being here. We really appreciate it. So MCPS is very pleased to be partnering with Potomac Community Resources to bring you an enhanced transition times and transition information for parents and students. So this has been a fabulous partnership for us. And coming up on Thursday, this coming Thursday, February 5th, we're doing our financial planning meeting, and the Zoom registration link is in this PowerPoint. So if you're interested, copies of our flyers in English and Spanish are linked in this PowerPoint as well. We do have interpretation services this evening. We have American Sign Language, and we also have interpretation services in Spanish. And at the bottom of your screen, there is a little interpretation icon. When you click that on, please select the language Spanish and mute your original audio, and you will hear the interpretation in Spanish this evening. And to maximize this experience, please turn off your camera and mute your microphones. If you select speaker view, you will see the person who is doing the presenting. Please put questions in the chat. Please make the questions general. We don't want to address any specific student-specific questions this evening. We will answer questions at the end of the presentation. There's also closed captioning available at the bottom of your screen. You can see the closed caption icon, and you can click that and you will see the captions. So we have two excellent presenters this evening that are going to talk to us about guardianship and supported decision-making. So we're going to start first with Mr. Daniel Cardile. He is an attorney with the Montgomery County Circuit Court, and he will start off talking to us about guardianship. So Dan, take it away.
Great, thank you so much. Well, and thank you all so much for having me tonight. I'm really thrilled to be here. I've done this presentation a few years now. Wait a minute, can you go back to the prior slide? It's my favorite slide. This is my favorite slide because not because it has my name on it, but this slide, guardianship, has the question mark on it. And also this slide is important because it says where I work along with 5 other lawyers at the Self-Help Center in Montgomery County, and the hotline number there at the very bottom. So if you decide at any point tonight that you're done listening to me, you've had enough of me, you don't want to listen anymore, no problem. You can go back to that first slide, you can call that hotline number, and I'll do it all over again with you over the phone. Okay, so just be aware of this first slide. If you don't learn anything else, learn this first slide, that's where we are at the Self-Help Center, Montgomery County, and that's the hotline number. Okay, thanks. I have this presentation set up in a series of questions. I like to present it as questions because, well, that's kind of the whole theme of the talk, which is to question. And question number 1, that's where we begin. This is my second favorite slide. And the question is, should I file for guardianship? And for maybe a small amount of you, the answer is easy, simple, absolutely yes. And maybe for a few of you, the answer will turn out to be easy, absolutely no. But I think that for most of you, it will be a question, and not necessarily a simple one, but a question that you need to ask yourself nonetheless. Should I do it? You don't need to. It's not legally required. Some people believe that it is, but it isn't. I will share that I have in my family 3 people for whom we could have filed in my family for guardianship. Of the 3, we only filed for guardianship of one of them. And I think that was the right thing to do. Still not sure, pretty sure, but it's a question, and you should ask that question of yourself as well. Okay, next slide, please. Question number 2. Okay, what is guardianship? Guardianship is a formal court process, and I keep writing the word process here on the slide because that's what it is. It really is a process. It's not a simple thing where you go to the court, fill out some papers, and boom, you're done, you're the guardian. Not even close. It's a process, and that's why I wrote process so many times. Guardianship is obtained through a court order, which is only given by a judge after notice to all the interested parties and at least one hearing. So a lot of things in that one little bullet point. We'll unpack that a little bit as we go along. Next slide, please. All right. Oh, true, false. Okay, we're already into the true, false questions. I love these. These are a lot of fun. Question number 3. True, false. All right. So to get guardianship, I have to, 1, decide if it's reasonable given my family dynamic. Number 2, obtain doctor's certificates. Number 3, do a petition. Number 4, file it with the court and pay a $165 filing fee. Number 5, serve interested parties and attend at least one hearing. True or false? My friends, the answer is true. All of that is true. Those are all basic things that you have to do in order to obtain guardianship, and even more things besides, but those are the basics. Okay, next slide, please. Okay, question number 4. Is there more than one type of guardianship? Yes, there is. There is guardianship of the person, and there's guardianship of the property. Some people file for just guardianship of the person. Other people will file for just guardianship of the property. Some people will file for guardianship of the person and property. And note that one person can be guardian of the person or person and property, or just property. And there can be multiple guardians of those things. Generally, the court likes to limit guardianship to one guardian or 2 co-guardians. The idea of guardianship is that one person or 2 people be speaking authoritatively for another person, not that there be, like 6 people or 7 people all speaking at one. That's not useful. So the court likes to limit it to 1 or 2 guardians. Next slide, please. Okay, question number 5. What is the legal standard to get a guardianship of the person? Well, there's kind of a legal standard here. There's a lot of legal mumbo jumbo here. You don't need to get too wrapped up in it. What you just need to know is there's a standard, and there's things that you have to meet when you do the paperwork and when you go to court. It's not just like going to the store and buying a loaf of bread. When you go to the store and buy a loaf of bread, nobody asks you, what's the legal basis for this bread? You just want the bread. Same thing with guardianship. A lot of people come to my office and say, well, I just want it. I just want it. Well, there's more to it than that. You have to meet standards, including the one at the bottom, which is that you have to convince the judge that there is no less restrictive form of intervention available. And that's a serious thing. A judge will actually press you on that as to what less restrictive forms of intervention you have tried in your situation. And if you have no idea about that, or if you haven't tried anything, a judge might decline to give you guardianship because, again, that's very important and it's also the law. Okay, next slide, please. What is a legal standard to get a guardianship of the property? Again, not going to dive into the legal mumbo jumbo about it. You just need to know that there is a standard. It's not nothing. You have to show that the person you're seeking guardianship of lacks the ability to manage their affairs because of a variety of reasons. And again, the last bullet point is a little bit important there. The person you're seeking guardianship over has or will be obtaining a significant amount of property, either in the form of real estate or money or an inheritance or something like that. Okay, and we'll come back to that. Next slide, please. Okay, question number 7. If my child wants to contest my attempt to get guardianship, what rights do they have in doing so? It turns out your child has a lot of rights to contest guardianship. Now, don't worry, that does not happen very often, but sometimes it does. And it's important to understand that, you know, your child has rights just like everybody else. And a guardianship is kind of a taking of those rights away from them and bringing them to yourself. The rights of decision making, the rights of self determination, the rights of managing your own affairs, the rights of managing your own property. You're taking those things away. Certainly, usually you're doing it out of love and out of you just care so much for your child that that's why you're doing it. But it is still a taking. It is still a taking of rights. And your child, believe it or not, becomes, in the guardianship case, your opponent, technically. And again, people hate it when I say that because, oh my goodness, I'm the mom, I'm the dad, I'm not the opponent. I'm just here to help and I'm doing the right thing. And you are, but you also become the opponent to your child legally in the court case. Your kids will have the right to notice, the right to counsel, the right to demand a trial if they wish, if they can. Uh, and those are all the things that they can do against you in the case. Again, not usually what happens, but it's possible. Okay, next slide, please. Okay, I'm thinking about filing a petition for guardianship. Who are the parties to a guardianship petition? Okay, well, the petitioners, and there's an S there, like I said a little while ago. You, as the parent, is certainly the petitioner. The other parent may also be the petitioner, may also be a petitioner, which makes you co-petitioners. It's not required, but it could be. Sometimes you're not on good terms with the other parent, so you want to be the only petitioner. Sometimes you are on good terms with the other parent, but it's just a decision that the easier thing to do is make one parent the guardian, and the other parent will just kind of go along with it. The other party, of course, is the respondent. That's your child. Like I said a minute ago, they become your party opponent legally in the court case, which again isn't something you should be nervous about. It's just something to accept. And if you accept that, then all the other things that you have to do in the case usually make a little more sense and become a little more palatable. Okay, other parties in a guardianship petition are the interested parties. We'll come back to that. So moving right along, next slide, please. Okay, oh, well, there it is. Question number 9. Here we are. What or who are interested persons? Okay, so as I mentioned, the other parent is certainly an interested party and may become a co-petitioner, but if they're not a co-petitioner, they are at least an interested party. Again, sometimes that's not a problem. Sometimes it is a problem because sometimes maybe you don't know where the other parent is. A lot of times you don't know where the other parent is. A lot of times the other parent is not cooperating. So that's an issue. And I have a lot of conversations with people who come in and they say, no, 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 forget the other parent. I have custody. I won custody 15 years ago. We're good. Not going to deal with the other parent. Forget it. Too bad, my friends. You're going to have to deal with the other parent again in this case in order to obtain guardianship. Interested parties also include adult siblings of your child, a spouse of your child if they have one, and children if they have them eventually, and any other lawful heirs that your child might have. The Social Security Administration is usually an interested party. The local Department of Health and Human Services, DHS, is generally, not generally, they are an interested party statutorily. Veterans Affairs sometimes are if a parent is a veteran, and other government agencies could be interested parties as well. Now, why is the Department of Health and Human Services a necessary interested party? Well, unbeknownst to you, there's people and entities kind of checking things out in the background. And if the Department of Health and Human Services, when they find out about this case, and if they check into it for a minute, and if they have any concerns that you might not be a good guardian for whatever reason, they're allowed to come to the hearing and explain why that might be. Again, you shouldn't worry about it, but there it is. They are a statutorily required interested party. You will be required to serve them. We'll get to that in a minute. And if you just understand and accept the fact that they are a statutorily necessary party to a guardianship case, I won't actually look it up, but here is this trust and estate statute book. It's in here, I promise. If you just accept the fact that they're in there, it'll make more sense that you have to take the time and a little bit of expense to serve them. Okay. Next slide, please. Okay, question number 10. Do these interested parties have rights too? Sure they do. Like I said a minute ago, they will all have the right to be notified, meaning, served. They can object to your being appointed as a guardian, and they can object to you being the guardian of your child. Again, not very common, but it does happen and it can happen, so it's important to be aware of it. Again, not to scare you, not to frighten you, but just important to be aware of it. After you become the guardian, the interested parties kind of remain. They kind of get to hang out there in the case and just sort of be there. Most of the time, they don't do anything, but they could reopen the case some years later and say, wait a minute. The guardian is mom, and mom has got a lot of problems now. Mom is in rehab, not okay. We need to change the guardian. So one example is that a interested party has the post-appointment right to file with the court and ask for a substituted and/or successor guardian. Just something to be aware of. Again, worry about. I've said that 15 times now. I'll probably say it a few more times. Very important to be aware of it. Next slide. Hey, let's look at a guardianship petition. I don't know if you have handouts. Maybe you do. We're not actually going to do a guardianship petition. We're just going to look at one. Here it is. Sometimes it's helpful to just see the animal so that it's a little bit demystified. Can I scroll through this? I'm not sure I can. Oh, great. Thank you. Well, page 1 just talks about, basic information, whether you're going to file for guardianship of the person or property or both, like we already talked about, some basic information about you. Then it goes on to the next page. And once again, it asks you questions like, have you been convicted of any crimes of fraud or violence? You answer truthfully. Then you move on to the third page, and it asks you some other questions. Oh, a very mysterious question, number 7. If the alleged, that's what they call it in these things, the alleged disabled person. If the alleged disabled person resides with you, state the name and address of somebody upon whom service can be made in lieu of the child, or in lieu of your child. Strange question. I'm not even going to explain it now, but just know that you put the name and address of somebody close to you, a neighbor, friend, or relative, upon which service can be made in addition to serving your child, because of the legal technicality that you're alleging your child does not have the capacity to accept service. So you have to name somebody else, and that's the one for number 7. People who do their own petitions for guardianship, brilliant people, rocket scientists, surgeons, cooks, maids, all brilliant people. 9 times out of 10, when they do it totally on their own and they file it with the court sends it back because they didn't do question number 7. They just skipped it. Well, don't skip number 7. Put down the name and address of somebody. Continuing along with question 8, basic questions as to who the parents are, whether or not your child has a spouse, or whether or not your child has any kids, that kind of thing. You can keep moving along. And then here we are on page 4, and whether or not there's other instruments over the child, whether or not there was a guardian previously appointed, whether or not the child has an attorney of record that is habitually that child's attorney for various things. Sometimes kids, I'm well aware of this, they get into trouble, they've had some offenses when they were younger, and they've got a lawyer that's already been involved in certain things in their lives. Hey, put down that person's name. They might want to, they might be useful in the case. Whether there's a supporter pursuant to a supported decision-making agreement, very important. If that exists, you put that there. If the child's already receiving Social Security benefits, it's important to put that there. You can keep going. Continuing on with government agencies. Here you see Department of Health and Human Services. If the child is under 65, you check box B. If the person you're seeking guardianship of, like for example, your mom, like I did, you check the box over 65. Names, and then some other just basic things like why is this guardianship necessary? And here's where you have to kind of write out some facts as to why it is that your child is not able to take care of themselves fully, that they're not able to, for example, sit down with a phone and schedule a medical appointment for themselves. You also have to describe, oh, there's that thing again, 11B. Describe the other less restrictive alternatives that you have tried before filing for guardianship. Again, I wasn't making that up. You have to put other less restrictive alternatives that you've tried before seeking guardianship. Because, of course, becoming someone's guardian, while it's very important usually, and almost certainly in your case done out of love, it's a very aggressive move. It's the most restrictive alternative to caring for somebody else. You can keep rolling. Here we get into guardianship of the property. Again, you kind of say the same sorts of things as to why your child is not able to manage their own affairs. For example, if they're not able to sit down with a checkbook and a computer screen and their bank account and pay bills, things like that. You also have to give a basic list of anything, ownership rights that your child might have in property. If it turns out that as you're doing this, the answer is none, there is no property that the child has, you might want to think about why you're filing for guardianship of the property and consider filing for just guardianship of the person instead. The court, more and more, at least in Montgomery County and in many other counties in the state of Maryland, not sure about other parts of the country, but certainly Montgomery County, and as I hear, other counties as well, judges and courts more and more, particularly with younger people, such as your kids, are pushing people away from guardianship of the property unless they have an actual existing hunk of money, hunk of property, hunk of inheritance thing, hunk of life insurance policy that's sitting there waiting for them to be utilized. Unless they have those things already, more and more courts are denying the guardianship of the property piece. You might say, well, wait a minute. My child is going to get Social Security income. If that's all that your child is going to have, don't do it, because the Social Security Administration will name you as the representative payee, and that's all you need. You get the money, you manage the money, it's all good. No need for you to then go back to the state of Maryland every year, which you would have to do if you're the guardian of the property, and write detailed financial reports as to what you did with every last penny of that money. It's a lot of work. You don't want to have to do it. And lots of times what happens is that people become guardian of the property when the only property is the Social Security money, and they don't really keep track of the money. And then when the end of the year comes, they don't do the fiduciary report. And then the court has to send them a letter saying, hey, you have not done the fiduciary report. We're going to have a show cause hearing about you. Show up. People get served with it by a sheriff. And I'm not sure how this translates into other languages, but they freak out. They get so nervous, understandably. And then they run to my office and they're so nervous, and they've been nervous for days. And nervous for nothing. It's just the court, you didn't do the financial report. And you didn't need to, because again, as far as the federal government is concerned, the one sending you the Social Security money, they're good. They're good. They sent you the money, you got the money, you spent the money, everyone's okay. All right. That's a long way of saying think about maybe not filing for guardianship of the property. But again, there are good reasons to do so. I do understand that Maryland Dable, very important for a lot of people, does like that. So if you're going to deal with Maryland Dable, very important organization, as I understand anyway, you're going to want to talk to them about that first. Okay, you can keep rolling, please. All right, and then you just sign a bunch of things, and that's that. So that's kind of it for the petition. Again, if you're doing it on your own, it's going to take you longer than that. But I hope that that kind of demystifies things. And remember, back to slide 1, if you have questions or concerns, you can come to the Self-Help Center or call our hotline number or hire your own lawyer. There's plenty of good lawyers in Montgomery County, Maryland. Okay, next slide, please. Okay, question number 11. What are certificates of incompetency? Okay, this is where you begin a guardianship petition. This is where you begin a guardianship petition. You need 2 of them. One of them has to be from a doctor, and the second one can be from a second doctor, or a nurse practitioner, or a psychologist, or a licensed clinical social worker. But you cannot file a petition for guardianship without the child first turning 18 years old, and you getting 2 medical certificates. Okay, so those are also in the handout, and those are also on the court website as well. Don't be nervous about them. Just schedule an appointment. Don't just send it to your doctor and say, "Hey doc, fill this out." They won't. Schedule an appointment. Bring in your child. Have the appointment. The doctor will go really fast, and you're good. You got it. Next slide, please. Okay, I've done a petition. Now, what court do I file it in? Easy, where the child lives, or if they happen to be in a facility or a hospital, wherever that facility is. Oh, if you're planning on moving anytime soon, it is a pain to obtain guardianship in Maryland and then you move to Wyoming. God love Wyoming. God love all the states of the United States of America. But when you move out of one state, having just obtained guardianship, you sort of have to do it all over again. It's a pain. Maybe just wait till you're in the place where you're going and file there. Next slide, please. Question number 13, true, false. Okay, I've filed and I've got show cause orders in the mail with show cause hearing dates. I'm good, right? I just show up at the show cause hearing? False, wrong, no. So many people make this mistake. They get this beautiful packet in the mail with show cause orders. They read the show cause order. It doesn't make a lot of sense. It doesn't make a lot of sense even to me, really. But you get to the bottom, you see the hearing date. Wow, yay, good. I just show up. Case dismissed or case rescheduled, big disaster, because you didn't do the thing in the middle, which is to say, serving all of the interested parties, which serving all the interested parties, kind of a big deal. That's its own 45-minute conversation. We're not going to have that whole conversation now. If you're going to do this entirely on your own, meaning the medical certificates and filing the petition and doing all that totally on your own, this is the service part, where you might want to get some outside help, either by consulting with a private lawyer or visiting the self-help center. Next slide, please. Question number 14, true, false. So my child will have a lawyer and can actually fight me on this. True, true. Don't worry about it. Doesn't usually happen, but it can happen. Again, like everybody, your child has rights. They're a litigant in a court case. They can fight back if they want. But don't worry about it. Just go with it. When the lawyer for your child calls you and says, "Hey, I got to set up this meeting," just go with it. Just cooperate. It's all good. Don't fight back. Don't be mean. Just cooperate. And also, this lawyer, and there's a variety of them that do this work, that get appointed, they might not be that nice to you. Too bad. They're not your lawyer. They don't care about your feelings. They care about the child. They care about your child's feelings. So just cooperate. It'll all work out. Next slide, please. What is the role of the lawyer? Again, I don't want to get into all this. They'll talk to your child, but obviously they have to go through you, and they'll advocate for the child's needs and wishes. There are certain ethical rules that are very nitty-gritty, and we're not going to get into those. legal ethic things, but if your child is expressing things to the lawyer that is objectively harmful to the child, the lawyer does have an ethical duty to say, whoa, whoa, and back off a little bit and not be just a pure usual lawyer zealot advocate. I'm going to go fight for whatever you want. Who cares what mom says? That's that there are ethical rules in guardianship cases that differ from ethical rules in non-guardianship cases. So don't worry. Next slide, please. Question number 16. What is the first hearing and what do I do? Okay, the first hearing is called a show cause hearing. Basically, it's easy. Well, when you get to that point, it's pretty much easy. You show up and explain to the judge why you're seeking guardianship and why that is necessary and what other less restrictive alternatives you have worked on before that day. You should expect to win at that first hearing, and that would be the end of the case, unless some interested party comes to show cause why you should not have guardianship. And that's why it's called a show cause hearing. Sometimes people come to our self-help center and wait 6 hours in our lobby just to be seen, just to ask, what does show cause mean? It's old-fashioned language from medieval England. Ye shall come and ye shall show cause why this thing shall not be granted. Show cause, show cause. The idea is, though, you've served all the interested parties, and none of them came to show cause. None of them showed up. So when you go to the hearing, you look behind you. No one's there. No one came to show any causes why you should not be the guardian, and you win. Next slide, please. Question number 17. Hooray, I won an order. I can pretty much manage everything now, right? Most practically speaking, yes. I mean, there are limits. As guardian of the person, you're supposed to only exercise those powers necessary to provide for the demonstrated need of the disabled person. So, it's not just like, hey, I'm totally in charge. I do whatever I want. It's only whatever is reasonably necessary to provide for the needs of your child. Of course you will. You love them. You'll do the right thing. You'll do what's best for them. There are legal limitations, though. In other words, for example, you cannot change the classification of their abode, like they can't be from a private house to a group house without further court intervention. And you can't have a commitment into a mental facility, again, without further court intervention. And you can't do things like end of life care without further court involvement. So there are not only practical limits, there are legal limits. Next slide, please. Guardianship of the person, rights, powers, duties. There's a lot of words here. Not going to get into it. Again, most things that are reasonable, that make sense to you as things that are necessary to care for the individual, you do those things. You determine where they live, you provide for their medical care, comfort, you look after their personal effects, you arrange for their basic services, and if someone else is the guardian of the property and someone else has control of the money, you arrange for that money to be given to you to utilize in taking care of the individual. Or if you're the guardian of the property, you just do both. Next slide, please. Order appointing guardian of the property. Again, a lot of legal words here. The general idea is you're supposed to only use the money that your child owns or possesses for their benefit. And that seems easy, that seems intuitive. It can become a bit of a gray area. Sometimes parents start to use it for things that are a little more personal to them. Not okay. It really has to be very specifically for the specific benefit of your child if you become guardian of the property. And in many respects, if you do become the guardian of the property and you are spending the child's money on things that are more clearly for you or for somebody else, you can get in some trouble for that. Not serious trouble, but you could certainly be stripped of your guardianship and there can be some consequences. So you got to be careful about that. There are certainly limitations. Next slide, please. Oh, okay. I mean, here's a long list of things. of guardian, that if you become the guardian of the property, that you can do. Most of these things don't apply to most people, but pay taxes, um, pay rent, pay mortgages, hold stock, um, manage property, pay claims against you if there happens to be a lawsuit against your child for any. Well, let's not get into that. That's a whole other kettle of fish. Interestingly, you can't, and I learned this recently when I became guardian of my mom. You can't just rewrite their will. Good thing, actually. So there's definitely limits. Um, if you become guardian of the property and you have questions about this, if there's enough money for that to be happening, I would consult a private lawyer that specializes in this area of law. Next slide, please. Um, Again, we're going to do this quickly. Day-to-day management. If you become guardian of the property, you can use your child's money for day-to-day management of things for them. You can, if someone owes your child money, you can collect money for them, pay taxes, financial planning, basic things like that. Next slide, please. Is there training for all this that you're required to do? Happily, yes. During the course of the case, of the guardianship case, if you do a guardianship case, you will be required to view a very good pre-appointment video and post-appointment video that is on the court's website. They will make you do it. They will make you certify that you've done it. I've seen it. It's fantastic. It's much better than me. It's slower. It's more normal. It's more perfect. You'll love it. It's very helpful. So you'll hear this all. You'll get a lot of this again, and a lot of maybe the questions that you have, those videos will answer those as well. Next slide, please. Question number 18, true, false. After I get the order, I'm done with all this court stuff, right? Wrong, false. You're not. If you become guardian of the person, you have to do an annual filing of the person report. Pretty easy. Just keep track of what the medical appointments were. The court kind of wants to know that. Kind of a list of, okay, on May 8th, on whatever date, we went to go see this doctor and took these meds, or this was prescribed. On this date, we saw this dentist and this happened. On this date, we saw the psychologist and this happened. On this day, we saw the dermatologist and this happened. Those are the main things to keep track of. You can probably do it in 15 minutes. You do it once a year. It's just writing a sort of a little love story about your child for the past year. People that come into the office to have help doing it, they love doing it. And I kind of like doing it with them because it's sort of fun. Next slide, please. Question number 19. Okay, again, I'm the parent, and I'm just trying to do the right thing for my child. Do I really have to go through all this? This is a question because I can't believe how often people come to my office. We go through all this stuff for an hour or two and doing the petition, and we're done doing it. And the person says, wait a minute, wait. Hang on. Didn't I tell you I'm the parent? I don't need to do all this, right? Right? Wrong. No, you do. You have to do all these things. In reality, your child is an adult. They're their own human person adult. And in reality, you are no longer their parent of a minor. They are an adult, and the court becomes their ultimate guardian. And if you then become the guardian, you take that over from the court, and that's a very important title to hold. And it's a lot of work. So that's the answer to question number 19. Next slide. I think we're almost done. Next slide, please. Okay, where can I find question number 20? Where can I find all these court forms? Go to mdcourts.gov. There's the link there, mdcourts.gov. And there you go. You go to, if you scroll back up there you go. There it is. Oh, there it is. They're all there. The family forms, the custody forms, and there's a whole section that says guardianship forms. There's like 80 of them. They're all there. So you can go back to the presentation. Thank you. Next slide, please. Oh, great. Ta-da. I'm done. Thank you so much.
Thank you, Dan. Do we want to have Dan answer the questions from the chat?
I think we should.
Okay.
All right. So the first one is, what is the biggest difference between guardianship and power of attorney? Is one better than the other? And can you file for either one at the courthouse?
Okay, they're very different things. You don't file for power of attorney at the courthouse. You don't file for power of attorney at all. You don't file for power of attorney. Your child would if they chose to and if they fully grasped it. You see, a power of attorney is a giving. It's a giving. I'm going to China and I give you the power to manage all of my properties, my apartments while I'm gone, collect all the rents and fix all the pipes. I'm out of here. You're in charge. Goodbye. I'm giving it to you. I fully comprehend it. I sign it. I notarize it. Other people sign it. There's lots of signatories. We're good. It's a giving. Guardianship is the exact opposite. Guardianship is a taking. And you would only be doing a guardianship because maybe your child can't do a power of attorney, because maybe they don't comprehend all the things that they're doing and they need someone to do it for them. That's kind of the idea. So, in a way, it's not like an either or, they're kind of total opposite things.
Okay, thank you. So the next question is, so it says for individuals who are disabled and applying for DDA services, the transition coordinator usually advise for the parents to wait until the child is 18 years old. What is the reason to wait until the child is 18 years old? Which I don't know.
Well, there's a lot of words there. I think that I'm gonna answer the question that I want to answer, even though it might not be the question that was posed. Until the child is 18, they're a minor and you're the parent, and you can do whatever things you can get away with as a parent for a minor, as any parent could for any minor. You cannot file for guardianship until the individual turns 18. You just can't do it. Why wait? I don't know. Because you can't do it. You just can't do it. If you file a guardianship petition before the child turns 18, you can do it. You can pay the filing fee. You can file it. The court will reject it, and you'll have to start over. It's just statutorily important. And I know I have worked with a lot of parents, children with developmental differences, and I have more respect for you than any other people in the world. You guys are the true heroes. You're so on top of things. You want to get this done now. You don't want to wait, because you have to wait.
Okay, but just to clarify, you're talking about guardianship, but that's different than applying for DDA.
You mean income?
They're
DDA.
just
Help me out. I don't.
um because they're saying my daughter is 18 in May. Why isn't it better to file before she turns 18? So there were some questions about DDA, which I
File
think
for.
would not apply to this.
That's correct.
I
Can I just intervene for one moment? So DDA would be Developmental Disability Administration. Typically, those services start at 21, but DDA is not income. There is a comment there, it's income. It is not income. SSI is income. So we host these in the hopes that we help you navigate through some of these acronyms and different titles and things you have to or should do or think about doing for your child as they become an adult.
Okay, that's much more clear. Okay, thank you. Okay, so is it possible to file guardianship if parent lost their parent's right for the child? Will that go to the next family that can take over before turning 18, before it goes under DDA? So the first question, is it possible to file guardianship if parents lost their parent right for the child?
It is possible because you don't have to be a parent to file for guardianship of a person. I could file for guardianship of your child. Anybody can. I'm not likely to win because I would have to serve you as the interested parties because you're the parents, and you would surely defeat me. Well, similarly, if a parent who lost parental rights previously files for guardianship, I don't know. There might be some very significant reasons as to why the individual lost their parental rights that make them maybe unfit to be a guardian, and they might very well lose, but I think they can. It's possible I'm wrong about that. I've actually never encountered that scenario before, so I don't definitively know the answer.
Okay, thank you. Do you have to update the guardianship form every year?
No. But you have to file you have to file an annual report, which again, pretty easy thing for guardianship of the person, pretty much more complicated for the guardianship of the property.
Okay. Does guardianship have permission to be involved in person's support finances? So I'm guessing that they're saying, does guardianship have permission to be involved in the finances of an individual?
Well, yes. You just have to only spend money directly on the individual for their benefit only, and you have to account for that each and every penny at the end of the year. So the best answer to that is yes.
Okay, thank you. Is the Montgomery County Family Law Self-Help Center walk-in only, or can you make an appointment?
It is both. You can walk in any day, Monday through Fridays. The doors open at 8 o'clock in the morning. You can also call the number on the first slide, leave a message. We call you back to schedule an appointment.
Okay, so this might have been from a question before, but it said, can you expand on what we might answer in terms of what least restrictive options have been tried or give an example?
Yeah, well, look, um, you're so enmeshed in your child's life. You're always trying things to help them flourish. And you want me to give you a canned answer to that. I will not. You will have to just think. And other people might give you a better answer to that. There are, for example, there is the very good example of, well, we attempted to work through a supported decision-making agreement, and it didn't suffice, or it wasn't comprehended, or something like that. Separate and apart from that, there's just a million things, if you really sit down and think hard about it, of things you've done over the years, weeks, and even in the past 2 days, where you've tried to sort of encourage your child to flourish and do things on their own. We'll say those things and say maybe why that had limits or why that did not succeed. Maybe it was trying to schedule their own medical appointment, but maybe it didn't succeed. So you could say that.
Okay, thank you. If you have to wait until the child turns 18 to file guardianship, then what happens if the child turns 18 and guardianship has not yet been granted and now the adult needs medical care and refuses it? How is the parent able to ensure the child obtains proper medical care during this gap in guardianship?
If it's an emergency, there is such a thing as filing for immediate temporary guardianship of medical care while you're waiting for the final guardianship case to run its 6 or 7 or 8 month course, and you can get emergency guardianship in an afternoon if there is such an emergency.
Okay, great. Thank
But
you.
then I don't, well, never mind. I've answered the question. There's usually a follow-up question to that, but I'm not going to answer.
Okay. If both parents died and the disabled adult came to live with you, how can you get court appointed guardianship, or is it better to become the guardian yourself?
Okay, great question. There is a spot in the petition, and I kind of glossed over it, where you can ask in the guardianship petition, it's question number 6, I am asking the court to appoint somebody other than me as the guardian. The easier thing to do, though, realistically, is to call the Department of Health and Human Services and say, hey, oh, tragic situation. I've got this person here with special needs, and their parents have both passed away, and they need help. Help. And the department can actually be the filers of the guardianship case and take sort of immediate guardianship.
All right, thank you. I am a parent serving as personal guardian for my 30-year-old daughter. I have no family to assume guardianship upon my death. Are there resources for identifying individuals who can serve as court-appointed guardians who I might interview and have assumed guardianship prior to my passing?
Well, that is a really interesting question. You really should get to know people at the Department of Health and Human Services as well as possible, so that they are aware that when you pass away, there'll be nobody there to take over. Alternatively, and I don't want to sound like a smart aleck, but I don't know, find anyone, take them out, take them out for coffee, get to know someone else, whether it's a friend, neighbor, relative, synagogue member, mosque member, church member, any human being that you know, and maybe involve them in your life with this situation. But if not, just go to the Department of Health and Human Services. I don't know of I don't know of a resource in particular that you are asking for.
Okay. Somebody says, I still don't really understand how to determine if you should file for guardianship. Is that usually determined from meeting with the doctor, psychologist, or as opposed to cooperative management, for lack of a better term?
Well, it could be the decision comes from a variety of sources, a variety of factors. It might very well be, for example, you schedule an appointment with a doctor and you meet with the doctor and the doctor does the examination and sits down to fill out the form with you for 5 minutes and the doctor says, golly gee whiz, I don't know. I don't really feel like signing this as a doctor. I think that your child actually probably could manage their own affairs with some support and some help. I don't feel like signing this. Oh, maybe I will, though, just because you're my good patient. And you might think to yourself, maybe I shouldn't do this. So that could be one way that you decide not to. Another way is maybe, and this might not apply to a lot of you, but you talk to your child. Maybe you do. Maybe they'll tell you. Maybe they'll tell you, heck no. Maybe you talk to the other parents. Maybe you talk to your siblings. Maybe you just watch and wait. Again, 3 people in my family, one of whom we have guardianship over, we waited a very long time before we did it. Now we've got it. Okay. Well, things were fine. Things were pretty good before, but it just became a little unmanageable, so we got it. It went on for like 25 years. It was okay.
Okay. So somebody's confirming, did you say the timeline process for guardianship is 6 to 8 months?
Well, if everything goes perfectly smoothly, I'd say about 4 to 5 months, but things usually go a little bumpy. So that's why I like to say 6 or 7. And sometimes things go poorly and you got to do things over 2 or 3 times. So it could be 8 to 9 months.
All right. Can I add one of my child sibling to be a guardian upon my death or his dad's death? His siblings are younger than him.
Not exactly. You can appoint another person to be a co-guardian, but that is the extent of it. You cannot arrange so that upon your death, it immediately goes to somebody else. It's not like, because that's too much like property in a will, and your child's not property. So you don't know 20 years from now that that's going to be a good situation. Maybe the future guardian is not wanting to do it 20 years from now, or they're living in Bangkok. You don't know. So the court doesn't really allow that. What the court allows is for you to make a co-guardian with another adult. And then when you die, that other co-guardian becomes the guardian. Of course, you need their cooperation. They might say, no, I don't want to do this. The other alternative is, as you maybe approach death, you could go to the court website and get the court forms about appointing a successor guardian And you might call your friend and say, hey, friend, here's some forms. When I die, go to the court immediately and become the successor guardian, and they'll do it.
Okay, thank you so much. So there's still some questions about when turning 18, right, to file for guardianship. Can somebody do it, like start the process 1 to 2 months ahead of time? So that way, since it takes a while, or do they have to literally wait till they're 18 to
You
fill
can
out the paperwork?
you can start the process by obtaining all the paperwork and ahead of time schedule the doctor's appointment so that on the child's 18th birthday, you've made 2 medical appointments. I've seen people do this. It's incredible. And then on the day after the child's 18th birthday, you go and you file for guardianship, and there's almost no gap at all. But no, you cannot file ahead of time, but you can prepare ahead of time.
Okay, great. And then what happens if I don't file or file late? But I'm not.
Nothing.
Okay.
I don't mean to be weird about it. Again, in my family, 3 people. One were the guardian of the other two. Could have been, but didn't. The third one, we waited 25 years. Was that late? I don't know. Might have been. I don't think so. 25 years. Nothing happened. It's all good.
Okay, so what is the difference between a medical proxy and POA? Nervous about emergency and medical care during pending guardianship.
I've answered that. I don't want to sound rude, but I've answered that.
Okay,
You, if if the child is 18 years old and 10 days and has a medical crisis, okay, well, you take the child to the emergency room and they're not going to say, hey, well, we're going to stand around and smoke cigarettes and do nothing until we get guardianship. No, they will save the child's life for as long as it takes. Then, within the next week or 2 or 3, you can get emergency temporary guardianship. And boom, then you can make those decisions. And then you've got emergency temporary guardianship while the case is going for the next 5 or 6 or 7 months. But the court does not just give you guardianship on the child's 18th birthday. And if you're feeling like it's, well, why not? And you haven't been paying enough attention to me.
all right. And then the last question, can I get power of attorney for my 21-year-old with autism instead of doing guardianship?
Well, no, but your 21-year-old with autism can give you, remember, power of attorney is a giving, it's not a taking. Your 21-year-old child can give you a power of attorney if your 21-year-old child takes the initiative to get all the forms themselves, reads it completely for themselves, and in the presence of a notary and multiple witnesses, signs the power of attorney, reciting out loud what exactly it means and what all the repercussions are of it. And if they clearly can identify all the ins and outs of what it means to the satisfaction of the notary and the witnesses, then yes, your 20-year-old child can give you a power of attorney.
Okay, great. And then we did have one last, so they're just confirming again, my child is nearly 21 and we've been managing everything for and with her. To date, it's working. So it's okay to keep functioning this way until it's no longer working, correct?
Oh my gosh, you should give the presentation next year. Yes.
Okay, fantastic. Well, thank you so much. These are all the questions. And I think from the feedback, like someone said, thank you so much. You reduced my stress. So, so
Thank you
thank
so
you.
much. Thank you. I'm grateful to be here. Thank you.
Thanks, Dan. Our next presentation is on supported decision making. So this is an alternative to guardianship. And we have Miss Sandy Balin, and she's a staff attorney with Disability Rights Maryland, and she is going to tell us all about supported decision making.
All right, thank you. Good evening, everyone. My name is Sandy Ballin, and I'm a staff attorney at Disability Rights Maryland. So, just as a brief background about DRM, we are Maryland's federally designated protection and advocacy agency for individuals with disabilities. So we are a nonprofit law firm, and we have different areas of practice. We have an education, children's mental health team, an adult mental health team, a housing team, and the team that I work on, which is the Developmental Disabilities Healthcare Victims of Crime Act team. Our team really focuses on providing legal assistance and legal representation for Medicaid and Medicare issues, accessing DDA services. And we also do a lot of investigations into abuse and neglect within residential facilities and nursing homes. But in addition to doing all that legal work, we also do a lot of advocacy work and education sessions, which is why I'm here tonight. Before I begin, just a brief disclaimer. Any of the information I give tonight isn't meant to be legal advice. It's just for general informational purposes only. But if you do require any disability-related legal assistance, you can call our intake line, and the number is on slide. And an intake specialist would be able to assist you and provide you the proper guidance. Next slide. And so for a brief roadmap of what we're going to be doing tonight is that I'm going to have a little bit of background about capacity and competency just to set some foundation. The meat of the presentation really is going to be about supported decision-making, or SDM. We're going to talk a little bit more about the other alternatives to guardianship and how it can work with SDM. I put everything into certain hypotheticals to just be able to see how it would operate. I also provide some resources, and at the end, I will take some questions. Next slide. So like I said, for the background, to just lay some foundation on key concepts when discussing guardianship and alternatives to guardianship. Next slide, please. So for a lot of the times when we're having these discussions, we always like to differentiate between capacity and competency. So decision-making capacity is exactly what it sounds like. It's a person's ability to make decisions. But decision-making capacity isn't a one-size-fits-all approach. Instead, it exists on a sliding scale, and we kind of say that it's on a spectrum, and it can change depending on various circumstances. So that can include something like the type of decision being made. Is it a major life-changing decision, or is it a minor everyday decision? It can even be when the decision is being made. Does it have to be made immediately, or is there some time to think about it? And especially in the context of what we're discussing tonight, it can also depend on the supports and accommodations being offered. Can you discuss the options with others? Can you research into ideas? Or do you have to make it by yourself without doing any research? So I included a little animation to kind of discuss supports and accommodations a little bit more. So on one end of the spectrum, you've got those decisions that require less supports and accommodations to be made. So for example, if you were to ask me in the middle of the day when it's a long weekend about what I wanted to eat for dinner that evening, it would be a relatively simple decision for me to make by myself. I might need some support in deciding whether I want to cook for myself, or whether I want to order takeout, or whether I want to go to a restaurant or have the food delivered. But I'm going to be able to make that decision relatively easily. Next one. But then you've got the decisions that require more supports and accommodations to be made. So for example, if you were to ask me bright and early on a Monday morning to make a decision about my 401k, it would be a little bit more difficult for me to do so, and that's because the circumstances are different. First off, I am less familiar with 401ks and finances as I am compared to knowing what I want to eat. And also, the circumstances are less than ideal. I'm not a morning person, so making these big decisions and life-changing decisions very early in the morning is not for me. So I'm going to need more supports and accommodations in order to make that decision about my 401k. I'm going to need someone to sit down with me and discuss my options, maybe take some breaks and be able to understand what those options are. But what's important to recognize is that in both scenarios, whether I needed less supports or more supports, I was able to make the decision by myself. I didn't need someone to step in and make the decision for me about what I wanted to eat or about my 401k. I was the one who made the decision. And in talking about alternatives to guardianship, that's the supports and accommodations that we're discussing. Next slide, please. And so decision-making capacity differs from competency. Competency is a person's ability to make decisions under the law. So whereas capacity is about what to wear today or what to eat, competency is about making and signing a contract, maybe consenting to a medical procedure. And the baseline is that every adult is presumed to be competent unless it is proven otherwise. And what that means is that all decisions made by the adult must be recognized by the law. Next slide. And so the reason that we always try and discuss about competency and capacity is that people with disabilities are commonly believed to lack both decision-making capacity and the competency to make their own decisions, and that they need someone to step in to make the decisions for them. And this belief leads to a lot of dangerous implications. It leads to discrimination in institutions, schools, and hospitals. It can lead to unnecessary institutionalization. It can lead to exclusion from activities. And especially in the context of today's presentations, it can be about a higher risk of being placed under unnecessary and overly broad guardianships. Next slide. So normally this is around the time that I would just give a brief overview of guardianship, but Dan did a great job of going through all of the different aspects of guardianship. So I'm not going to go into depth about that. But what I do want to recognize is that even though I'm not trying to say that guardianship is never necessary, it's important to recognize that there are certain dangers of petitioning for guardianship. So when a person is placed under guardianship, they lose the ability to make many important decisions for themselves. And that can be the right to make their own medical decisions, the right to handle their own finances. And in certain instances, it can even be something as simple as the right to vote. And too often, guardianship is plenary in the sense that it's overarching and it's permanent, in the sense that once it's imposed, it's very difficult to terminate or limit that guardianship. And we even saw this in a real life example with pop star Britney Spears when she tried to get under the conservatorship of her father. She experienced difficulty in accessing the medical records needed to terminate the guardianship. Sometimes there's difficulty in obtaining counsel because certain counsel does not want to interact with guardians in fear of not being able to access certain information. And there's also the bias that the individual with a disability cannot make decisions for themselves. And in fact, this was seen in Maryland with certain attorneys who were representing clients with disabilities, that they weren't respecting the wishes and preferences of the individual with the disability, and instead substituting what the attorney believed was best. So with all of this said, what is the solution then, instead of the dangers of guardianship, to resolve the dangers of guardianship? And the solution is using less restrictive alternatives to guardianship, one of them being supported decision-making. And next slide, please. Next slide, please. So what exactly is supported decision-making? Supported decision-making is a cross-disability decision-making tool. So just like you've got powers of attorney or advanced directives, supported decision-making is one of those tools that can assist a person with making decisions. And it can be used regardless of an individual's disability, whether they have a physical disability, a mental disability, or an intellectual disability. And it allows a person to be able to keep their own decision-making authority without having someone appointed to make the decision for them, for example, like a guardian. And the nice thing about supported decision-making is that it can be used for various decisions. And this includes, but isn't limited to, healthcare decisions, such as like looking at medications or even consenting to the procedure, education decisions, housing decisions, and even financial decisions. Next slide, please. So how does it work? So this is a very basic way of understanding it, but it seems to work with when I'm doing these presentations. So first you've got supporters. Next, who help an adult make, communicate, and effectuate decisions through helping an adult understand the choices so that an individual can make the decision on their own. So we use supported decision making in our everyday lives when we're making decisions. We just didn't know that there was a term for it. So for example, how I use supported decision making in my life. So I went to law school in St. Louis, and when I got my job in Baltimore, I was apartment hunting by myself for the very first time, which of course is a very scary prospect. So I turned to the different people in my life to be able to help me with that. So I turned to my parents, who are more familiar with the home buying, the apartment hunting process. I turned to my brother and my uncle, who lived in Virginia and could tell me what was realistic to look at in apartments in the area. But then I also turned to my coworkers, who were familiar with which areas in Maryland were good for people my age, for people who had my interests. And so I got all that information from the different people in my life and got different advice from them. But I was the one who ultimately made the decision on where I wanted to live, and I was the one who signed the lease. And that's what's important to supported decision making, is that I made the decision regardless of what everybody else who helped me believed. And I can tell you for a fact, my parents were not happy with my choice of an apartment when I first signed the lease. And next slide, please. So who are these supporters, or what is a supporter? A supporter is a person who helps an individual in the decision-making process. So that can be a family member, a friend, a staff, or a professional. What's important is that the adult making the agreement chooses the supporter. The supporter doesn't choose the adult. And because the supporter might need to have access or be in appointments, for example, it's important that the supporter is someone that the adult knows and trusts to be able to have that information. In an agreement, an adult can have more than one supporter. So they might have one supporter for healthcare decisions and another supporter for financial decisions, for example. And the supporters can resign. So if they decide that they no longer want to be a supporter, they can choose to no longer be a supporter, but they can also be removed. So if an individual feels that the supporter is overstepping or that they're no longer the most appropriate supporter, they can choose to remove them from the arrangement. Next slide, please. And so what's the role of a supporter? So I divided it into what a supporter can do and what a supporter cannot do. So a supporter can research into options to help the person make an informed decision. They can help understand the effects of a decision. They might even be a part of appointments or meetings, of course, if the individual consents to their presence, or they might even advocate for supports or accommodations. So that can be more time to make decisions, for example, or taking breaks at meetings or appointments. But what a supporter cannot do is, again, they cannot make a decision for the adult. If there's anything that you're going to get out of my presentation tonight, it's that a supporter cannot make a decision for the adult. A supporter can also not implement decisions. They can't access information without the adult's consent. They can't act for an individual on their behalf. They can't exert undue influence. And they also cannot act outside of the authority granted under an SDM agreement. Overall, though, what a supporter has to do is that they have to act honestly, diligently, and in good faith, and essentially just support the wills and the preferences of the adult that they're supporting. Next slide, please. So if you're chosen as a supporter, what tools can you use? So how a supporter may assist depends on the adult's preferences. Some adults might want more help, others might not want a lot of help. But some of the potential tools is that maybe a supporter will provide plain language materials to adults to make it easier for them to understand information that, for example, is given at a doctor's appointment. They might even take notes at appointments to help the adult remember what was discussed, as long as the adult gives permission for them to take notes. They might even role play decision-making scenarios. And they might even create pros and cons lists of the different decisions that an individual can make. The thing about supported decision-making is that it is becoming increasingly popular. So even just a simple Google search will allow you to see what tools are available for people. But there are two examples in particular that I always like to highlight. One of them was a tool developed by the South Carolina SDM project. It's called the Stop, Look, and Listen tool. So essentially in this tool, I will send the proper link, but essentially in this tool, what it is that an individual and supporter work together to determine which skills a person needs to develop and how the supporter can assist with developing those skills. My personal favorite, though, is the 100 Ways to Use SDM, and it's by the ARC of Northern Virginia. And the reason I like it is because it divides SDM into different ways that it can be used. So, for example, as you can see, SDM in employment, SDM in relationships, SDM in housing. And I really like it because it just shows how SDM can be used in a variety of different facets within someone's life. Next slide. So how do you create an SDM arrangement? So first off, the adult has to choose who will be the supporters. Once they choose who will be the supporters, they also have to choose how the supporters will help. And again, that was looking back at the tools. Will they attend appointments with the adults? Will they help them research into choices with the adult? But what's important to recognize is that all states that recognize SDM arrangements may have certain requirements in order to make an SDM agreement valid. And Maryland is actually one of the states that recognizes SDM arrangements under their law. So next slide, please. So in Maryland, the law was created and passed in 2022, recognizing SDM as a less restrictive alternative to guardianship. So what that means is that courts must recognize that it's been used and that it's failed before they can impose guardianship. So when we were talking about those less restrictive alternatives to guardianship, SDM is one of those recognized less restrictive alternatives. The SDM law also prescribes elements to create a valid written agreement. What's important to note is that in Maryland, a formal written agreement isn't needed to create an SDM arrangement, but an individual can choose to have a formal written agreement. And if they do, there are certain elements that the law prescribes. And additionally, the law also outlines limitations and safeguards of SDM agreements. So I'm going to go into the Maryland SDM law a little bit more in depth, just to show what is now recognized under the law in Maryland. And next slide, please. So as I said, in Maryland, it's not necessary to create a formal written agreement, but if an individual decides that they want to have that formal written agreement, there's certain requirements that the agreement must have. So first off, it has to be documented in writing and it has to be dated. It has to name at least one supporter and describe the assistance they will provide. So for example, the adult chooses mom to be the supporter for healthcare decisions. It also has to have specific language about the supporter's authority. So in the same example, adult chooses mom to be supporter for healthcare decisions and have her attend appointments with the adult. It also has to describe how supporters will work together if there's more than one supporter. So like I said, there can be more than one supporter. So if there are more than one supporter, they can either work jointly, meaning together, or they can work successively, meaning if supporter 1 is unavailable, then they can turn to supporter 2. You also have to describe any perceived or actual conflicts of interest between the supporters and how to resolve or mitigate those issues. And this can really come up if a supporter is a staff or a professional, for example. You also have to document how the adult selected the supporter. So going back to the adult selects mom to be healthcare supporter because she's a nurse and understands my medical needs. The agreement also has to state that the supporter cannot make decisions for the adult. Again, the most important part of supported decision-making. It also has to state that the agreement does not affect the authority of an agent under a power of attorney. It has to be signed by the individual and the supporters, and it has to be signed and witnessed by 2 individuals who are not supporters or agents and employees of the supporters. So in Maryland, there's not also a specific form that has to be used, but on DRM's website, we do have a model agreement, and I believe that the model agreement was also sent out before this presentation. And it also has the guiding values that are, and yes, the sample supported decision-making agreement. And the nice thing about it is that it is a Word document, so it is editable. So you don't have to go through all of the different elements. And next slide, please. So a question I get asked a lot when I discuss about formal agreements is what's the good thing about informal agreements versus formal agreements. So in informal agreements, it's less prescriptive. It's more flexible and easier to change. And if a supporter, for example, is going to be a professional, professionals may be more comfortable with acting as a supporter if they don't have to sign a document. But for formal agreements for third parties, especially doctors or even financial institutions, they may be more willing to accept the decision if there's a formal agreement behind it. And that's because SDM arrangements are still relatively new to these third parties. So being able to say that this supporter is able to be in the room or at the appointment with me can be really helpful for the doctor to know that there is a formalized agreement. But additionally, it also helps clearly identify supporters, their roles, and what kind of supports they will offer. And that's really important, for example, if the supporter is overstepping in their role and they're starting to make the decision, the adult can turn to the formal agreement and let them know that they signed it and that they're aware of what their role is as a supporter. Next slide, please. And like I said, that the law also provides certain limitations for an SDM agreement. So the agreement cannot be required for participation in a program, activity, or service. The supporter also cannot be a minor, a person against whom there's a protective order, or a person convicted of financial exploitation. And finally, the way an adult communicates cannot be used as a way to prevent someone from entering into an SDM agreement. So for example, if a person communicates through assistive technology, or they communicate nonverbally, that can't be used as a way to say that they aren't able to choose a supporter or create an SDM arrangement altogether. Next slide, please. Just like there's limitations, there's also safeguards for SDM agreements. So first off, the most important safeguard is that the supporter cannot make decisions for an adult. Additionally, the law prescribes and limits liability for professionals who, in good faith, honor the SDM agreements. It also limits liability for professionals who, in good faith, refuse to honor the SDM agreements because the agreement is invalid. And an agreement might be considered invalid if, for example, it doesn't hit those formal requirements, or if a professional feels that the supporter is overstepping in their role as a supporter. And additionally, a guardian whose authority is not impacted by an SDM agreement cannot prevent one into entering into one without good cause. So for example, for guardian of the person who makes a healthcare decision, they can't prevent an adult from having a supporter for financial decisions without showing good cause. And what constitutes good cause really depends on what a court determines to be good cause. Next slide, please. So how supported decision-making differs from guardianship. So in guardianship, of course, the guardian is the one who makes the decision. But in supported decision-making, it's the adult who makes the decision. So consenting to medical treatment, signing a lease. They just have help from the supporters. The supporters, though, are not the guardian and they don't make the decision. There is also no cost to create an SDM agreement. No notary is also needed. No lawyer is needed to create one. An individual can create an SDM agreement without having those parties involved. And in fact, no court approval is needed either. And no court is, you don't have to go get it confirmed by the court or filed with the court. There is an exception to that. If there's a guardianship order, a court will need to get involved if the authority of a supporter conflicts with the guardian's authority. That is the only time that the court will need to get involved. Otherwise, this doesn't need to be filed with the court. You don't have to go to the courthouse, have a lawyer defend you. And that is why supported decision-making is something that we advocate for, because it is very person-centered. Next slide, please. So the importance of supported decision-making, again, goes back to those dangers of guardianship. So people with disabilities are regularly subject to those plenary guardianship orders. And it's sometimes based on the bias that the need for supports and accommodations means that they can't make any decisions for themselves. And of course, that's not always the case. SDM respects people's voices and their choices, regardless of their age, disability, or the way that they communicate. And it promotes the idea that you start with the less restrictive alternatives first and progress to the more restrictive ones if absolutely necessary. And again, I do want to reiterate, I am not trying to argue that guardianship is never necessary. In some instances, I have clients that it's absolutely clear that they do need a guardian. But supported decision-making and also other less restrictive alternatives promote that idea that you don't necessarily have to start with guardianship first. Next slide, please. So supported decision-making, like I said, is one of the other alternatives to guardianship. But there are also other alternatives out there that can be just as helpful as supported decision-making and can work together with supported decision-making. Next slide, please. So just like there's guardianship of the person and guardianship of the property, when I do these discussions, I also divide it up into personal alternatives to guardianship and the financial alternatives to guardianship. So I'm not going to go into too much depth about all of these, but I will just do a brief overview. So on the personal alternative side, you've got the advance directive, which is the medical power of attorney, where an individual appoints an agent who will make the medical decisions in the event that an individual is unable or unwilling to do so. There is also surrogate decision-making, where there's a decision maker appointed by law if there is no advance directive available. There is also person-centered planning through the Medicaid waivers, where the individual is at the center of determining what services are necessary. And then there's also the limited guardianship orders, where guardianship is limited to what is absolutely necessary. On the financial side, there's also the financial power of attorney, which is like the advance directive, but limited to finances. There are also ABLE accounts and special needs trusts. There's the direct deposit. There's debit card and credit card limitations. There's also the representative payee program through the Social Security Administration, where there is a representative payee who will assist the beneficiary of the Social Security funds. There's also something known as a specific transaction, where an individual can just go to the court and have them authorize just one specific transaction, as opposed to having them be complete guardian of the property. And additionally, there is also limited guardianship, again, where it's just limited to what's absolutely necessary. Next slide, please. So how does this all relate to SDM? So like I said, SDM can be used with these other alternatives to guardianship. So for example, for representative payee, for surrogate decision maker and guardians, where there is a decision maker being appointed. Supported decision making can be used informally to include the adult in the decision-making process and show them how the decision maker reached an ultimate decision. And what that allows is that it allows the adult to be able to develop their decision-making skills, and then at one point, maybe not have to have a surrogate decision maker or a representative payee or even a guardian. There's also, for the ABLE accounts, the supporter can help with getting connected to financial counseling, managing funds, budgeting, or making transactions. And for power of attorney, whether it's the medical power of attorney or the financial one, SDM can also be used. So if an adult is unable to make a decision and the agent needs to make the decision, SDM can still be used to include the individual in the decision-making process, similar to the representative payee, the surrogate decision maker, or the guardian. But if the adult is able to make the decision and they're the ones in the driver's seat, they can use the agent as a supporter to help with ensuring that others are respecting the adult's decision, and they can provide any support in making, communicating, or effectuating the decision. So the nice thing about SDM is that it can be used with these other alternatives. It doesn't have to be used alone. That even if a person has a guardian, SDM can be used in a way that allows a person to develop the decision-making skills so that they may be able to go to the court later and prove to the court that they can make the decisions on their own. Next slide, please. So alternatives in general should be considered because it really comes down to the idea of self-determination. So studies have shown that people who exercise greater self-determination have better life outcomes. They can live independently. They have better money management skills. They're less likely to suffer abuse, and they're more likely to identify situations where they could be abused. And overall, they just have greater community integration. So when we're doing these presentations and when we're advocating for alternatives, we're really trying to hone in on the fact that people with disabilities deserve the right to make their own decisions, even if they just have a little bit of help. Next slide, please. So I know I provided a lot of information, so I decided to have two different hypotheticals just to be able to show how SDM might be able to operate. So next slide, please. So for example, in healthcare, Alice is 19 years old and she has a disability. She has no guardian, but her mother is an agent under her advance directive and can make decisions only if Alice is unable or unwilling to do so. Alice's sister is a supporter under an SDM agreement. Alice wants her sister, who is a nurse, to attend doctor's appointments with her to help her understand what's being discussed. Alice has a doctor's appointment to discuss potentially having surgery on her leg. So what can happen is that Alice's sister and her mother can attend the appointment with Alice and help her with making a decision on whether to have surgery or not. But Alice is the one who has to ultimately consent to the surgery. Her sister or mother cannot do so. And that's because her sister or mother is not a guardian. Even though Alice's sister is a supporter, Alice is the one who has to make the ultimate decision. And next slide, please. So we talked about healthcare decisions, but now there's financial decisions, but the individual has a guardian of the person. So Ben is 25 years old and he has an intellectual disability. His mother is guardian of the person, but he doesn't have a guardian of property. His father is a supporter under an SDM agreement and will assist with financial decisions. Ben wants to open a bank account, and so he goes to his local bank to do so. Ben can have his dad attend the meeting with the banker as long as he gives permission for his dad to be there. Ben's mother, though, cannot prevent Ben's dad from being his financial supporter, and that's because Ben's mother is just guardian of the person. She is not guardian of the property. But Ben will make the ultimate decision about which bank account he wants to open, even though his dad is acting as a supporter to assist with the financial decisions. Next slide, please. So here are just some resources that can be helpful that we give out to people who are interested in supported decision-making agreements. So on the Maryland Legislature's website, there is the Maryland SDM bill text. What I tell my clients is not to be afraid to attach that bill text to the agreement if they have a formalized agreement. Because supported decision-making, again, is relatively new, just being able to attach that bill text to the agreement shows third parties like doctors or financial institutions that the SDM agreement is valid and that it must be recognized. And additionally, again, on DRM's website, we do have model forms and information about supported decision-making, and we have the supported decision-making model agreement. And on the right side of the screen, there are just some general information for supported decision-making. There are those two tools that I talked about. There's also the National Resource Center for Supported Decision-Making. The ACLU Disability Rights Program has their own library of SDM resources. The Center for Public Representation does too. And even the National Guardianship Association has actually promoted the use of SDM as a way to ensure that people's decision-making can increase and that it can improve over time. Next slide, please. Thank you again for listening. I know I provided a lot of different information, but I really do appreciate all of you taking the time tonight to be able to listen. And next slide, please. Again, here's my contact information, but I'm ready to take some questions.
Okay, great. So the first question is, can I use this? This was in the beginning of your presentation, and someone said, can I use this to talk to insurance companies, banks, and doctors?
So you can do it for as long as you have the permission of the adult who's making the agreement. There are other ones called an authorized representative. Again, that's an alternative to guardianship too. And under an authorized representative, it's basically that you're able to discuss medical issues with insurance companies. You're able to discuss that on behalf of the individual. So you can use SDM agreements to be involved in the meeting, but you can't use it you can't say I'm a supporter under an SDM agreement. You can only talk to me. I hope that
Okay.
answers that question.
Yeah, thank you. Do you know if other states have SDM, like Virginia, Delaware, Pennsylvania?
Yep, they do. Not all 50 states, but a lot of the states now are starting to recognize it. But even if you create an SDM agreement in Maryland and you move to, let's say, Pennsylvania or to DC, your agreement will still be valid. Or even if you have an SDM agreement in another state, it will still be valid in Maryland. It's just if you create an SDM agreement in another state, you have to make sure that under their law that you're following the requirements that are there. For example, in DC, DC, you can have a formal agreement, but DC's law has a formal agreement within it. It's not like Maryland where there is not a specific.
Okay, thank you. That's great. Is there a form or can I get help with doing a formal agreement?
You can certainly get help with doing a formal agreement if you need to. We're at DRM, we're trying to arrange some sort of clinic to be able to do that because it can be a tricky process to navigate. The form in itself is pretty self-explanatory, or the model form that DRM has. It is pretty self-explanatory and it walks you through all of those elements. But if you do need assistance, you can definitely contact DRM to see whether we're so that we can provide some assistance and walk through the process.
And they can access this form on your website?
Yes, correct.
Okay, fantastic. Okay, what do you do when your child needs decisions made when it comes to finances and medical that are above their level of understanding? For example, my daughter needs her appendix removed. Would I be able to override her decision because she may not understand the importance of why she needs that surgery?
So not with the supported decision-making agreement. You can't be able to make the decision on her behalf that way. But again, this goes back to the different forms that are available, that there is she can give you the power of attorney for you to be able to make the decision if she is unwilling to. So for example, that would be for the medical decisions that you can get the advance directive form and be able to make the decisions on her behalf.
Okay, thank you. Okay, so if there is no court document, how do you prove to a medical professional or financial institution that you can be present?
So that's where a formal agreement would be very helpful, because even though you can have an informal verbal agreement, having that formal SDM agreement laid out where the person says my supporter can be with me at the appointments, and showing that to the financial institution or to a medical professional can be very helpful. I always advise my clients, if they're interested in creating one, to have the SDM agreement be a part of the adult's medical record, so that regardless of where they are within the medical field or whatever healthcare professional knows that that person is able to be a part of discussions with the doctor, be a part of discussions with the specialist.
Okay, so you would actually, because the second question was, do you have to carry around the agreement and give it to the doctors, because many of them won't talk to the parents because their loved ones are over 18.
Right. Yeah. So give it to them. And like I said, attach that bill text to it also, because we're trying to do these presentations to healthcare professionals too. But if you can let them know that there is a law that recognizes supported decision making, they're more likely to accept it. We've heard it from medical professionals before that they weren't aware that this was a thing. So if you provide them with the actual bill text too, they're more likely to accept it.
So I know you had talked before, but someone asked about sharing a formal agreement with your office to advise or assist before signing, just to kind of maybe look it over.
Yeah, definitely. If you've created one and you just want us to look it over, we can definitely do that too. Yeah.
Okay. Can my child have SDM in addition to self-directed services?
Correct. Yes, you can. You can have it with self-directed services is through DDA, so that's a separate thing altogether. But SDM, a lot of people, when I explain SDM to them, it's like having an advocate. So you can have SDM in addition to self-directed services.
Okay, great. And then do you get the form notarized?
You don't need to get an SDM form notarized. And that's one of the nice things about supported decision making, is that as soon as it's signed, and it only has to be signed by two witnesses who are obviously not the individual, not the supporter, or employers or agents of the supporters.
Okay, fantastic. All right. I think that was the last question. Before we wrap up, I'm going to launch a poll. If you guys can just fill it out, the attendees, I really appreciate it. Thank you. Margie, do you want to wrap it up?
So if everybody could please, if you're still on, please answer the poll. We would appreciate it. Thank you so much to Sandy and to Dan. The information was fantastic. We really appreciate you coming every year and doing this. And thank you all very much for being here. Again, we have recorded this meeting, and Melissa will send out the recording and all of the PowerPoint presentations and everything to everybody that registered for the meeting. So, any other questions?
Oh, fantastic. And we're getting lots of great feedback you guys can see in the chat. So thank you so much.